Boom. Hey, folks. I don't know how long or hoss long, I guess, it was sitting there because I hit start and then it just had me sitting there with my face. And I'm like, are we going to roll the intro? Because I'm hoping we roll the intro. I've got to do a better intro than this. But yeah, I was just like, So if I was sitting there looking perplexed, then yeah. And if otherwise it just was maybe slow to start. So people are asking, am I feeling better? 80%. And I feel like part of why I might not be feeling as well is that like mosquitoes have been... the mosquitoes really found me to be delicious. And so Mrs. Runkle was not eaten alive by mosquitoes. She was sitting there. She was having a great time. And I was like, the mosquitoes are really coming after me, like really coming after me. And she's like, oh, they're not so bad. And I'm like, no, they're coming after me. They're that's what they're doing. And anyway, so she was a little skeptical. And I never used to be that I was the one that the mosquitoes would ignore. But anyway, the later when going to bed, Mrs. Runkle was looking at my legs and she was like, holy crap, they really have gone after you. So yeah, I was eaten more or less alive. But yeah, good times. So we have a whole lot of stuff to cover. Now, I was hoping to try to do this stream from the land and to try to do a stream from out there, either from inside the fifth wheel or possibly possibly one where I'd set it up with like an extension cord and a laptop and a secondary monitor and maybe like some nice sort of pond as a background. But I ran into some technical difficulties when I was doing sort of a final pre-test this sort of early afternoon, and then I was like, well, we can't do that. We gotta run. So we got a bunch of stuff to cover here, and yeah, some of it is lawyers behaving badly, some of it is other court misadventures, and we have as much tea as we want to take. There is so much tea because the tea case is one that affects like a hojillion people. And so there's like, I don't know, a couple hundred pages worth of tea documents because lots and lots of lawsuits. Now, I suspect that tea is not going to continue to exist after this. And yeah, I think that we'll see that. There's also a new update in a case that I've already had people requesting me to cover. They're like, hey, can you cover this latest update? And the problem is that it's a case I can't really talk about right now until I get like my lawyer's okay. So, hi, Benji. But yeah, we'll see. I will probably have to pursue it and go from there. But yeah, I know, and I'll talk about why I'm saying hi, Benji, a bit later too, because yeah, there's so much. What is it? So much to discuss, but I can't really do it now without sort of the sign off and the okay. And I got somebody saying, "What?" Long story. So, all right. Let's see. Darn it, Runkle suit out stream. I, we'll see. Wait, so lawyers have lawyers? Yes, that is a thing. Lawyers sometimes have lawyers. Can you cover Aaron Spencer? I am not up to speed on Aaron Spencer. I am going to be looking into it because I've had a lot of requests to look into the Aaron Spencer thing. I will be looking into it. I have not as of yet. It's one of those cases where I want to look into it thoroughly because the original, like the initial glance at Spencer says, oh my God, what the hell is this? Why are they pursuing a case here? But I don't know if there's going to be more to it or if it's just going to be that the case is crazy. So let's see. Where do we? Ooh, I got a hiccup. Where do we start? What's a good warm up, Kate? Oh, I've still got more hiccups. Still got more hiccups. All right. So, where's a good start? Yeah, let's have a look at a news story. Oh, and what is it? Any chance of getting a Potter and Zora view? Right now, Potter and Zora are they are with Mrs. Runkle at her parents' place, so I have no Potter and no Zora here. Let's do a goal here. I've got a couple of. Here we go. Goal, crack a beer. There we go. All right. So, hey, Vez, good to see you. What is it? I need to get back to you. We got to organize something because, yeah. Okay, so let's talk about one of the craziest things I've heard of in a while. It's this one is a little bizarre. It is a little wild. So let's have a look. Oh, and I got to actually hit bring to stage. So, judge rejects Goo's latest legal move. And you might be saying, who is Goo and why do we care? Well, so Allison Goo, also known as Allison Ling, has to be prepared to go forward with a hearing about a criminal defendant who secretly tried to hire about a half dozen non-English speaking actors to serve as witnesses for her in a $1.6 million bank fraud case in southern Vermont. This is truly, truly wild. So she is arguing that all of her previous lawyers before, during, and after trial were in some way lacking. She wants her conviction overturned. She wants to strike a restitution order. And yeah, so she this court case, and I'll drop a link in the chat here. This is the Manchester Journal here. So she's indicated that she is upset that She's indicated she's upset because she is concerned that her previous lawyer failed to use 7 Chinese-speaking actors that the defendant recruited and were provided scripts about what to say during the jury trial. The scheme to provide fake witnesses made public when Judge Rice directed Shelkrot to report on her efforts to defend Gu, who would normally be blocked from disclosing defense effort, but she wanted an affidavit. And yeah, so what happens? They went to have a trial, and there were a whole bunch of bogus witnesses that were brought in. Bullshit witnesses. And these bullshit witnesses were brought in, and what is it? They specified that one of them happened to remark, "It's for the movie." And Shelkrot asked, "What movie?" And the witness said, "Are you a real lawyer?" So basically what happened in this case is that the defendant hired a bunch of actors, at least this is the allegation, and provided them with scripts for what to say. And that was not actually, they were not actually witnesses. Now, this is freaking wild. Like, this is insane. And it's like, how could that possibly be a thing? But it's a thing, apparently. So good times, good times. She better have been looking at life in prison. No. She was actually sentenced to 3 years in federal prison. And you might be wondering, well, 3 years, how much did she defraud? But the defrauding was to the tune of 1.6 million is the allegations, which she was convicted on. So, yeah, that is a whole choice, right? Apex Sid, I am not super familiar with that one. And I'll have to get back to you because, yeah. This one is bizarre, and it's a good warm-up. So, yeah, somebody says all that for 3 years. I actually suspect that if they turn around and bring additional charges, she could end up getting more than 3 years for that particular move. So, we'll have to see. But that is a very, very real possibility if she ends up getting charged with that. So, all right. Let's see. What else should we cover? I guess let's go on and cover Lally. Now, I saw somebody saying, is Bettero joining? Not to my knowledge. He's welcome to if he wants, but I haven't spoken with him to invite him on, and this one is short. So I thought you got caught in the rain. Why do you look sunburned? Because I spent a lot of time in the sun. The rain lasted for about an hour. The rain lasted for about an hour. And what is it? It wasn't too bad. It's just that once once that sort of went away, it was like, all right, fair enough. So, and yeah, Bettero is on vacation to an unknown warm place with family. Then he's definitely not going to come in there. Apex, I'm going to say stop talking about your case on Twitter. Either shoot me an email at runkleofthebailey@gmail.com or yeah, I'll try to get back to you. So, all right. Isn't Canada part of the land of the midnight sun? Part of it. The land of the midnight sun is a term for like the northern parts. And the reason why is that you get like periods where you get nearly 24 hours of sunlight, and it sucks. But I am not in the 24-hour sunlight part. I am in the not 24-hour sunlight part. So, which is a much nicer part. All right. Let's look at the Lally stuff. Oh my goodness, that is super tiny. Let us try to fix the Lally stuff so that it won't be super tiny, which might take a second here. Yeah, there we go. Can I make this less super tiny? Yay! All right. Here we go. Now, this is the case of the Commonwealth versus Miles King. Now, you might be saying, wait a minute, who is Miles King? As it turns out, there's more than one person in in the Commonwealth of Massachusetts who gets charged with things. And Miles King is apparently a rapper who is facing charges. I believe it's, murder. So, yeah, it's a big deal. Now, previously, we covered some issues with, and I don't actually have the PDF. All I've got is shared, like, image screenshots. But Lally was brought in, and I previously covered his hearing where he was testifying that about disclosure that the defense didn't get. And Lally is brought in to testify because he was previous, assistant DA on the file. And basically his testimony was incredibly pathetic, because what he gets up and, testifies to is he testifies that basically he asked for the material. He didn't get it. He asked again. He didn't get it. He took no steps. He did no things. He just did not give any shits. And the thing is that, it was some of the most doesn't give a fuck about his job testimony that you can ever imagine. He's just and he just doesn't seem to care about the fundamental rights of the accused. So, Lally is going to have another continuation of this hearing tomorrow. Except his lawyers are big unhappy about this. His lawyers are really unhappy about this because they have filed a motion to limit scope of questioning of attorney under subpoena. So on May 28th, 2025, the defendant in this matter filed a motion to dismiss, or in the alternative, release on bail and continue the trial date given the voluminous late disclosed evidence. After that motion was filed, the parties jointly requested that the court continue the trial date and reduce the defendant's bail to $2,500 with conditions. After hearing, the court allowed the request for a continuance and set the bail at $10,000, which is weird that they went from $2,500 joint position to $10,000. But the defendant posted the cash bail on June 27th. So that's actually not that long ago. That's like a month ago. By the way, the defendant has put out a new music video about getting released. So that's its own thing additionally. So what are they asking for? The court should suspend Lally's testimony unless and until the defense makes a preliminary showing as to all three required prongs required for dismissal. 1, egregious government misconduct. 2, prejudice to the defendant's right to a fair trial. And 3, a showing that dismissal is the only remedy for the prejudice. Now, the thing is they're saying suspend his testimony until the defense makes a showing as to the required prongs for dismissal. His testimony is necessary for the defense to like the defense is calling him in order to establish these things. Recent procedural background. The hearing on the motion, now addressing only a motion to dismiss since the trial date was continued and the defendant was released on bail, was scheduled for July 21st. ADA Lally was issued a subpoena by defense counsel to appear at that hearing, and this matter is scheduled for July 21st. He appeared and began testifying over his attorney's objection. At that hearing, the court directed counsel for the, and then I got to switch pages here. There we go. For the defendant and the Norfolk District Attorney's Office to work together to specifically identify the scope of discovery that was disclosed late to the defense. The court also directed counsel for the defendant to review the materials and to identify specifically any exculpatory evidence that was disclosed late to the defense. What does exculpatory mean? It means more likely to lead to an acquittal, right? Stuff that is helpful to the defense. Now, that is one of two categories of material that has to be disclosed, the other being inculpatory evidence. You might be saying, if it isn't exculpatory and it isn't inculpatory, then what is it? Other than that, it would be irrelevant, right? It's either exculpatory, inculpatory, or irrelevant. Inculpatory would be stuff that makes it more likely that the accused would be convicted, right? Teresa B says that says a lot about an attorney's competence when they ignore their own attorney's recommendation to stay silent. I don't think Lally watches a lot of law too. Lally did not want to testify. He was subpoenaed. He's required to testify. This is not a situation where he's able to remain silent. They're requiring him to testify. So Attorney Lally testified on July 21st, and it was a disaster. And the hearing was continued till August 5th. Oh, look, that's tomorrow. With the expectation that the parties would have narrowed the scope of the discovery at issue and counsel for the defendant would have identified what she claimed to be exculpatory and prejudicial. Before Attorney Lally's testimony recommences in this matter, counsel for the defendant should comply with the court's directive and identify how the evidence at issue here is exculpatory and how the defendant has been prejudiced, particularly given that he's been released on bail and the trial has been continued. Can't he claim the fifth? He could, if it's something where there's a possibility of him facing, sanctions. But if he claims the fifth, then I think Mr. Cash is going to walk. I think this, becomes real bad for them if he pleads the fifth. So, all right. Without two of the requirements should comply with the court's directive and identify how the evidence at issue here is exculpatory and how the defendant has been prejudiced, particularly given that he has been released on bail and the trial has been continued. Without two of the requirements for dismissal under Commonwealth versus Trepania, the defendant's motion fails and a testimony from Attorney Lally becomes unnecessary. Should the court still wish to hear from Attorney Lally, we, the undersigned counsel for him, respectfully suggest that his testimony should be strictly limited to the issue of whether his conduct constitutes egregious misconduct, which in light of the 26 notices of discovery providing unique discovery each time, certainly does not. I don't know. I don't know where the I is there. Ethical issues are not covered by the right against self-incrimination. Yes, if he's pleading the fifth, he needs to assert that there is some sort of issue of criminal potential. And it would be wild to see Lally assert the fifth on this one. So I hope he doesn't. I mean, for Lally's, that would be a very bad move. So Commonwealth versus Trepania, issued by the appeals court last Thursday, is on point and dispositive, where the defense has not made a prima facie showing of the three prongs required for dismissal, and the court has already taken significant remedial actions in this case. Last week, the appeals court issued its decision in Trepania. This case is worth a close study. Like this case, it emanates from an allegation of late discovery of evidence that was ultimately disclosed. And we're just pulling up. Sorry, these are not easy to work with because it's not a PDF. So, yeah. I can't imagine what criminal offense would be covered here either. But it is, I mean, yeah, I don't know. We'll see. Pre-trial. In that case, the trial court issued an order to produce the discovery, but included what should have been excludable time under the Rule 36, ultimately leading to dismissal. The appeals court was clear that dismissal of the charges is a sanction for a violation of the rules, in the absence of a finding of irremediable harm, was an abuse of discretion. In a footnote, the appeals court acknowledged the 2025 amendments to Rule 14, including to the sanction provisions, but wrote, "We discern no substantive change in this language. Rather, we think it merely provides an illustrative list of sanctions to aid litigants and judges. A dismissal with prejudice under Rule 14 still requires a showing of irremediable harm. In order to warrant dismissal, there must be egregious prosecutorial misconduct and prejudice to the defendant's right to a fair trial, and dismissal must be necessary to cure the prejudice." So what does it mean to have irremediable harm, right? Well, let's imagine that there is a... we're going to go with Bob because, of course, we're going to go with Bob. But let's say Bob, let's say Bob is accused of killing Joe. But there's a witness, an independent witness, who says, I saw the murder, but I don't think it was Bob. Bob is like 6 foot tall. This guy was like 5.5 at best. So I don't think it was Bob. That's a very helpful witness for Bob, right? Bob loves this guy. Bob thinks this witness is the best thing ever. Except Bob doesn't know that this guy exists because the prosecution has not told Bob this guy exists. Why wouldn't they tell Bob? Because, well, the prosecution finds this guy to be... they very much rather that Bob not use this witness, right? So they hide this witness. They don't tell the person about this witness, right? They just they say, okay, we're not going to share that. And I see people saying that I've hit the goal. I've hit the goal. All right. I got some of my garage leatherworking stuff there. So, whoa. Beer is trying to explode on me. So, now the prosecution eventually decides that they can tell Bob about the witness. And the reason why they decide that is because the witness is walking down the street one day. It's a fine day. He's just out to get some air. And the witness is hit by a garbage truck and is run completely over. And then the garbage truck driver picks up the witness's body, throws it in the back of the truck, hits the compactor a few times, and drives off. The witness is gone. No witness available. So now they tell Bob, hey, there was a witness. There was a witness. And he's dead. So at this point, it's become irremediable, right? Because you can't fix it by telling Bob that this witness exists, because the witness is no longer available, right? They waited too long, and now this witness can't be explored by the defense. So, yeah. That's kind of an example of irremediable harm. Now, what is it? neither of these Bobs. Different Bob. Different Bob. So, now they say the remedy of dismissal is only warranted when there's egregious government misconduct, prejudice to the defendant's right to a fair trial, and a showing that dismissal is the only remedy for the prejudice. In this case, should counsel for defendant fail to identify for the court how any of the documents at issue are exculpatory, and therefore the late production prejudiced his right to a fair trial, and where counsel for the defendant failed to show how dismissal is necessary to cure the prejudice, given that the trial date has been continued and the defendant is released on bail, the defendant's motion could be denied without further testimony from Attorney Lally. In any event, Attorney Lally's testimony should be strictly limited to the issue of egregious government misconduct. The court will learn that Attorney Lally was diligent, well-meaning, and that his conduct aimed to conform with his obligations as a prosecutor. Now, I actually think that it's a bit of a problem that they're like, hey, we're going to hear that Lally was diligent, and I'm like, no, you didn't. None of his testimony was that he was diligent. All of his testimony was that he just basically gave few, if any, fucks about this. I don't see how they can say that he was diligent here. But it is wild that they have a prosecutor on the stand, and that prosecutor has a lawyer. Oh, and yes, yes, the law firm is Butters Brazilian LLP. Somebody spotted that, and I'm like, it is indeed Butters Brazilian. So, okay, I don't know why it's Butters Brazilian, but Butters Brazilian. I assume that there's a lawyer named Butters. I assume that there's a lawyer named Brazilian there. I don't know. Otherwise, it sounds like, the latest sort of influencer fad that results in lawsuits. So, yeah. So let's talk about tea for a bit, and then we can come back. And if we need a nice dessert, we've got a sanctions order. But so you might be saying, what is the tea? I see some people asking, what is the tea? Well, the tea case is, how do I describe this? So, how do I put this? T is/was a dating app. And, people are asking for a swoop. I can do a swoop. I can also do another goal. All right. What should I set as a goal? I don't know what a good goal is. I'm just going to put... I'm going to put hot sauce testing because I still have hot sauces. All right. So what tea is it's an app that was aimed at being for women only. And the purpose of this tea app was to allow for women to get basically background information on the on people they might be dating. You might be saying, what kind of background information? Well, they said that they would do criminal record checks. They said that it would include scanning the internet for all of their socials, which to my mind is bizarre, right? To my mind, it is just bizarre. Somebody's asking, and trans, I don't know how they, I don't know what their policy was there, but it also allowed for people to like post warnings and various other comments about guys who either they were dating or that somebody might want to date. Now, the way T worked, T, in order to sign up for T, they wanted to make sure that you would not sign up as a guy. They wanted to make sure that men would not sign up. And so what they made people do is they made people authenticate with like pictures and IDs, and often IDs with their picture. Yeah. So they promised that when people signed up with those, with all that information, that they would, keep it secure and then delete it, that they would eliminate that and destroy it. So what did they do instead? Well, they didn't do that. They instead stored it. And you might be saying, well, at least they stored it, and they, they stored it in a secure place, right? That they preserved it, right? Nope. They did not do that at all. Instead, they just dumped it all into a publicly facing storage bucket, which anybody could go and access. And so people did do exactly that, especially because T started getting discussed on Twitter, and T started getting discovered essentially because people were commenting on kind of the sexism of it, and also kind of the potential for defamation, because there is real potential for defamation on this. And some of this is going to be defamation of the most easily litigated kind. What do I mean by that? Well, let's say you go on T and you, let's say there's a guy you dated once, and the guy was a real asshole, right? The guy was a real jerk face. He came over, he got drunk off of your booze. You never did anything, but, he got so drunk that he decided that, like, your grandma's urn was a urinal. And then after that, he stole your car keys and drove home. Real jerk. But you don't post, hey, this guy stole my, stole my urinal, and or stole my grandmother's urn and used it as a urinal. Instead, what you post is, I think this guy's got herpes. Or maybe you don't put I think. Maybe you just post, this guy's got herpes, do not engage. And maybe engage is a different word. But so the problem is that if you have now alleged publicly, and publicly can be as little as one other person. Like if I send a message to specifically, Wolf Chiara, and say, hey, Bob's got herpes, then that is defamation per se. The other way to get to defamation per se very easily is by alleging that somebody has committed a serious crime. A crime of let's say you allege that you were sexually assaulted by somebody. Well, if it's not true, that would be defamatory. So basically, the T is a defamation farm. And it's a real, so people got upset by this. And because they were upset, people started looking at the T a little more closely. And that's why they found this giant bucket of information. But because they were upset, and, a lot of guys who are kind of awful people were upset by this. Not just awful people, but awful people were, there was a lot of awful people who were upset. They decided to dump this data online, and they shared it on 4chan, various other things. So this is a major issue because now the T is being sued so many ways. Now, you might be saying, why is, why is this a problem? Well, people's driver's licenses are getting leaked. Their, addresses are potentially getting leaked. It is absolutely insane. So let's have a look here. Let's have a look at what is going on. And we're going to look at one of these cases. And then, we might look at more as well, but we got a bunch of different cases to cover because there's lots of them. So we'll start with one, and then we can move on and sort of look at others as we, as we go. So let's have a look here. Somebody says, I thought 4chan had been destroyed. Nope. Nope. So, so Jane Doe individually and on behalf of all others similarly situated. By the way, they're not all Doe cases. Some of them actually name the people. So, class action complaint. Plaintiff Jane Doe individually and on behalf of all others alleges as follows. Introduction. Now, keep in mind, this is, as Emily likes to say, allegations in shade. We haven't proven anything yet, but here we go. So this case arises from one of the most catastrophic and ironic data breaches in the digital age. A safety app designed to protect women exposed their most sensitive personal information to the darkest corners of the internet. Defendant, which marketed itself as a sanctuary where women could anonymously warn each other about dangerous men, instead became the very threat that it the very threat it promised to protect against. So yeah, this one is pretty awful. Rolling along, can't talk about it for now. We will talk about it again when we can. On July 25th, 2025, the unthinkable happened. 72,000 images, including government-issued IDs, sat completely exposed on the internet, accessible to anyone with a web browser. This was not an elaborate hack. T stored its most sensitive user data in a Google Firebase storage bucket configured for completely public access. Anyone who wanted could simply click and download the most sensitive personal information of women who trusted T with their safety. This is important because the issue there is that there is no protection fully against hackers, right? I mean, you could do your best, but even really big companies like Fortune 500 companies and so forth get hacked occasionally. But this was not a hack, right? This was not hacking because, for example, it's like the difference between somebody picks your lock and breaks into your house and steals your stuff versus you left it on the front porch, right? This is the equivalent of they just left their shit on the front porch and they just hoped no one would notice that it was sitting there. And sure enough, they did notice and they took it all, right? So, yeah, it's nobody broke in. Unlike a typical breach, this data breach was discovered not by T's security team, nor even by ethical hackers, but by anonymous users on 4chan, the notorious image board known for harassment campaigns against women. Within hours, now, to be fair to 4chan, they don't just have harassment campaigns against women. They also have harassment campaigns against all sorts of people. 4chan is not a wonderful place. Within hours, these users had created automated scripts to systematically download every image. Indeed, some users even complained that they were not able to download the photos fast enough. And so we've got an image here. I've downloaded 3,000, but now it seems it's being rate limited, ? For plaintiff Jane Doe and tens of thousands of women like her, the nightmare was just beginning. Users quickly created an interactive Google Maps link that overlaid pins onto a map of the United States, showing the location of roasties, the women who had their photos leaked. And so the thing says, I made a map of the roasties, enjoy, and there's a map. I apologize for the slang. It's what's in the thing. And it says, roasty is a slang term that primarily refers to a woman who is perceived as having a promiscuous lifestyle, often in relation to having multiple sexual partners. The term is often used derogatorily to imply that such a woman is undesirable or has lost value in the dating market due to her perceived sexual history. The term roasty refers to like roast beef. It is a pretty obnoxious comment about women's genitalia and their belief of what happens to women's genitalia when they engage in activities. And basically, these are people who have never actually seen women's genitalia that weren't like downloaded from the internet. So, yeah. Glamasu says, I've heard them called round heels. That's a little archaic, but I will. So, yeah. So the driver's licenses leaked today from the T-app have been uploaded to a searchable map. This may be the worst personally identifiable information leak I've ever seen. So you see this map, and are you able to hear me? Testing. Can you hear me? I didn't mute myself. Some sort of technical issue happened. Okay, sorry folks, I didn't mute. But technical something, I don't know if the technical things will come back, but yeah, we'll have to see. The fallout continued to get worse. Users of 4chan created an ELO ranking system, a method for calculating the relative skill levels of players in various competitive games such as chess, to rank the foids, randomly pitting two random leaked women's photos against each other and assigning points to the woman whose photo was ranked higher. The ELO ranking system even has a top 50 and bottom 50 leaderboard. So 4chan was doing 4chan things. What is it? So are these men who want to revert back to the Middle Ages? Not really, because in the Middle Ages they would probably be like, probably be serfs who would just but yeah. So instead of protecting women like Jane Doe, T's shocking security failures handed their identities to the very predators they sought to avoid. The exposed data created a perfect kit for identity theft, high-resolution government IDs showing full names and addresses and selfies, many including EXIF location information, among other sensitive and private information. For women who use T to report dangerous men, the breach didn't just compromise their financial security, it potentially exposed them to physical danger from the very people they were warning about, now with maps of T users floating around the darker corners of the web. There's a potential public online humiliation of the sexist, sexual, and violent kind, and the potential for deepfakes. Now, I just want to note here. I just want to sort of note that I think the deepfakes thing is kind of bullshit, because the deepfakes thing is just people have a picture, and I'm like, okay, that's not really like whatever. But there are real concerns that somebody might be posting on T going like, hey, my ex tried to murder me. And then and then T is like, oh, by the way, we're just going to post this online. Right? So along with your current address, potentially. So, and they note here, FOID is a slang abbreviation for female humanoid. The term is often used in online communities, particularly within certain subsets, the alt-right, incel, involuntarily celibate communities. Generally, it denotes a cold or detached view of women, reducing them to a mere biological category, and often used in a derogatory context. So, yeah. Notwithstanding defendants' myriad failures, it represents that it takes cybersecurity seriously and that it implements reasonable technical, administrative, and physical controls. So, security of your personal information. The security of your personal information is important to us. By the way, if this is slang you didn't know, don't worry that you're missing out. Like, this is not something that you need to worry that you like, oh, am I out of touch? No, this is the reason why you would be why you'd be sort of knowing this is either that you do criminal defense, and so you end up seeing some of those people and whatever else, or you're going to you're spending time in like pretty dark corners of the internet. This is like incel talk, right? And so what are incels? Incels are people who are involuntarily celibate, which means basically they would like to be having sex, but they are not able to do so. Now, there's nothing wrong with not having sex, and there's nothing wrong with people who are not succeeding in the sexual market. But there is something wrong with the people who make it their entire identity. Like, yeah. The more time, like if you are in that category of, involuntarily celibate and unhappy with it, about it, the more time you spend in those communities, the worse you are making your life. Like, these are not communities that are set up to make your life better. They're communities to get you into a sort of an introspection spiral that just leads to you having worse and worse chances of ever actually pulling out of it and dealing with the world like a human being. So, yeah. And yes, it was originally, the person who came up with it was not that's sort of a whole backstory, but yeah. It's a whole sort of thing there. So use of personal information we collect. During the registration process, users are required to submit a selfie photo for verification purposes. This photo is securely processed and stored only temporarily and will be deleted immediately following the completion of the verification process. Womp womp. It was not. Defendant reassured the women that used its app that it deleted these verification selfies. This was simply false. Defendant posted an official statement regarding the data breach, stating in relevant part, "I thought the selfies were deleted. This data was originally archived in compliance with law enforcement requirements to cyberbullying prevention." Now, I don't know what cyberbullying prevention would require them to store people's IDs. I don't see that as actually a thing, right? That seems to me to be complete bullshit, but yeah. T promised Jane Doe and millions of women anonymity. It promised to delete verification data. It promised safety. T broke every one of those promises. In an age where data breaches have become commonplace, this case is striking. An anonymity platform that exposed names, photos, and locations, a safety app that made its users less safe, a tool meant to allow women to protect themselves that instead handed their personal information to anyone passing by. By the way, if you're giving your ID to a web page, you should assume that they will eventually leak it, right? You should assume that that is a thing. The nightmare continued. T reassured the victims that the data set was limited to a legacy data storage system that was compromised, resulting in unauthorized data or access to a data set from prior to February 2024, and that no email addresses or phone numbers were accessed. Only users who signed up before the February 2024 were affected. This was false. Images were not the only data compromised in the breach. On or about July 28, 2025, T announced that as part of our ongoing investigation, we have recently learned that some direct messages were accessed as part of the initial incident. For this reason, our DM functionality is down. False, too, was the statement that the DMs that were simply part of the initial incident. According to news reports, T exposed much more user data than what was first. Proofread your shit. With an independent security research now finding it was possible for hackers to access messages between users discussing abortions, cheating partners, and phone numbers they sent to one another, with messages from early 2023 until up to last week, with more than 1.1 million messages recorded. By the way, the only way for your messaging to be secure is if their messaging is set up such that like these messaging programs should be set up such that even the messaging company can't access the stuff. It should be end-to-end encrypted and not but the thing you might be saying, why don't they end-to-end encrypt it? Well, they don't end-to-end encrypt it because they want access to that information. They want to be able to look through it and to like mine it for stuff, right? They want to be able to use it for advertising. They want to be able to all of this stuff. So the reason why companies over and over and over again don't end-to-end encrypt it is because all of these companies, I don't know about T specifically because I don't know enough about T particularly, but as a general rule, companies want to mine your shit in order to sell it and to show you ads, right? So everything wants to spy on you. So, all right. So they are suing because they want to seek money and to prevent such a betrayal from ever happening again. So plaintiff Jane Doe wants to proceed under a pseudonym because her private information was leaked, and then people would start looking her up. Jurisdiction and venue, we're going to skip because it's usually boring, and it's boring at this point. It might become unboring later, but right now it's boring. So T, the first ever, additional factual allegations. T, the first ever dating safety platform for women, is an app that provides a suite of dating screening services to women based on information about men obtained through crowdsourcing from the app's users and public records. T advertises that its services enable users to find verified green flag men, run background checks, and identify potential catfish. The other thing I'm just going to mention is that there is no person on the planet ever, like at all, there is no person on the planet who is entirely green flags. Why? Because, well, that is just not how people are. People, and somebody who is shitty at one point might grow as a human. And I worry that we enter into a world where we, where we can't be in, like, I mean, here's the thing. Like, we've all done stupid shit. We've all been stupid people. Somebody who's 18 is probably doing stupid things online right now. But when they're 25, maybe they've grown as a person, right? And the other thing is that what might be a red flag to one person isn't a red flag to another person, or, so, like, some people want somebody who is, some people want somebody who is, like, really attentive, and some people might say that that's clingy, and yeah. See, as a woman, I can say you're counted as a green flag when you do the bare minimum and are a decent guy. Yes and no, that is your standard, because I can say there are other people who, I'm not going to name who I'm thinking of because, she might watch it, but I have watched a woman I know go through relationship after relationship, and her concerns are always trivial and trifling. And the issue isn't that she's dating bad guys, because she never actually is giving them enough time to find that they're bad. The issue is just that she's got some mental health issues and she needs to work through them, because she rejects guys on the basis of, like, the most trivial shit. And, that's her call. She's allowed to do that. But I also wonder about, like, what she would be like on a T app. Because if she was on this, app going on saying, like, this person is a terrible guy, well, maybe, but, like, the terrible guy thing might be something like, didn't take her to an expensive enough restaurant or that kind of thing, right? So it's hard to say, right? It's hard to say. All of these things are its own sort of concern, and this app sort of might end up giving too much credence to stuff like that. So, all right, carrying on here. So T advertises that its services enable users to find verified green flag men, run background checks, and identify potential catfish. The app's exclusive nature, only verified women could join, added to its appeal. To join T's exclusive community, women had to pass through a stringent identity verification process. This was not a simple email confirmation or phone number verification. T demanded government-issued photo ID, driver's licenses, passports, state IDs, along with other sensitive and private information. Defendant made promises and representations to plaintiff and class members that their personal identifiable information would be kept safe and confidential. I've not even finished one, and I'm mangling my words here. And that the privacy of that information would be maintained. I don't think it's the beer. I think it's just my mouth trying to catch up with this. Plaintiff and class members' personal identifiable information. We're just going to call it P because, yeah, I know it's going to sound stupid, but we are children. We can laugh about it. Was provided to defendant with the reasonable expectation and on the mutual understanding that defendant would comply with its obligations to keep such information confidential and secure from unauthorized access. They had a duty to adopt reasonable measures to protect the information from involuntary disclosure to third parties. And they also had obligations created by the FTC, industry standards, and representations made to people. If you promise people stuff, then you typically have to, deliver. We are at 5 out of 10. Oh, we did not reach the hot sauce goal. All right, we're starting it up again because I don't know what else to put for a goal. Other than throw super chats to make Runkle unhappy. Defendant's data breach was imminently foreseeable. Defendant's data security obligations were particularly important given the substantial increase in cyber attacks and /or data breaches targeting institutions that collect and store personally identifiable information, like defendant preceding the date of the data breach. You should have known people go after this stuff. Data thieves regularly target institutions like defendant due to the highly sensitive information in its custody. So defendant knew and understood that unprotected information is valuable and highly sought after by criminal parties who seek to illegally monetize that through unauthorized access. So I'm just going to say, I see that I've got a super chat I should address right away here. And we're going to do this. Do you still plan to do a 4-hour beads versus meads video? Yes, but I need to recover a bit. My throat is still sore. Please don't let that get lost. Your sarcasm when applied to OPCA content is great. Thank you so much. We'll have to do that at some point. We'll have to see. I'm not going to get through all of the T cases today. But I may have to do T stuff later. So yeah. All right. Skipping ahead a little bit. T knew exactly what he was collecting. With these images and other sensitive information, criminals could potentially create deepfake videos for fraud or harassment, bypass facial recognition security systems, impersonate victims in video calls with banks or government agencies, build comprehensive profiles for stalking or doxing, and sell verified identities on dark web marketplaces, among a myriad of other harms. Now, some of these are bullshit, but some of these are legitimate concerns because, it is really there is a real possibility that somebody will have their identity stolen here. Somebody's going to sign them up for a credit card. Somebody's going to sign someone up for, a mortgage, something like that. And all of that is, potentially an issue there. And I see sort of a request for me to discuss the get home bag. When this goal runs out, we'll probably do that. So, yeah. All right. Skipping ahead, once the information is stolen, fraudulent use of that information and damages to victims may continue for years. T proceeded to collect this information from numerous women, storing it all in one convenient location, all protected by precisely nothing. Randolph, I will do a video on that at some point. So, the value of the information. The FTC defines identity theft as a fraud committed or attempted using the identifying information of another person without authority. The FTC describes identifying information as any name or number that may be used alone or in conjunction with any other information to identify a specific person, including, among other things, name, social security number, date of birth, official state or government issued driver's license or identification number, alien registration number, government passport number, employer or taxpayer identification number. Alien as in immigrants, not as in ALF, by the by. So, yeah, yeah. So the personal identifying information of individuals remains of high value to criminals, as evidenced by the prices they'll pay through the dark web. For example, it can be sold at a price ranging from $40 to $200. Criminals could purchase access to entire company data breaches from $900 to $4,500. So, and this is citing to various things. So for what things sell for on the dark web, this data also fetches a higher price on the black market. Compared to credit card information, personally identifiable information is worth more than 10 times on the black market. Why? Because credit card information doesn't... Credit cards are pretty locked down at this point. Credit cards tend to be, they don't get a high value from ripping off credit cards these days. So, whereas they might get much higher from creating a false, taking out a false loan against somebody and that kind of thing. So, defendant failed to comply with FTC guidelines. And the FTC has concluded that a company's failure to maintain reasonable and appropriate data security for consumer-sensitive personal information is an unfair practice in violation of Section 5 of the FDCA. They have more stuff on guidelines, recommends that companies not maintain personally identifiable information longer than is needed for an authorization of a transaction, limited access to sensitive data, require complex passwords to be used on networks, and the FTC has brought enforcement actions. I suspect that the FTC will get interested in this on their own, not just as a result of not just as a result of this lawsuit. So, defendant failed to comply with industry standards. So, industry standards are included but not limited to educating all employees, strong password requirements. Hey, that's a... I've got a... I don't think it's a mosquito bite. I think I've got a splinter that I've got to deal with later. So I just noticed a splinter that I've got to dig out. What is it? Multi-layer security, including firewalls, antivirus and anti-malware software, encryption, multi-factor authentication, backing up data. That's the only thing they were good at, was backing up data that they were supposed to delete. And implementing reasonable systems to identify malicious activity, implementing reasonable governing policies, and limiting which employees can access sensitive data. Defendant failed to follow some or all of these industry best practices. The biggest thing is they failed to follow all of it. All right, I'm going to kill the goal because there has been no interest in it. I will start a new goal on a brief get-home bag discussion, because goal is not interesting, people. It is what it is. All right. Now, the thing is that this is kind of missing something here, because there's just no cybersecurity here, right? They talk about things like, moreover, a properly trained help desk that understands how to face social engineering attacks. There was no social engineering attack, right? There was no anything. Defendant failed to meet the minimum standards of any of the following frameworks, and they list a whole bunch of things. Failed to comply with any of these accepted standards, thereby permitting the data breach to occur. Put bluntly, this wasn't a sophisticated hack or attack by nation-state hackers. This wasn't a zero-day vulnerability that no one could have anticipated. Defendant failed at the cybersecurity threshold, failing to implement basic security measures, including bothering to even set a password to protect its customers' personally identifiable information. This wasn't about a help desk. This wasn't about social engineering. This wasn't about any of that. This was purely about them leaving this data right in the open. And yeah, and most people are waiting for their social security checks to arrive. Or I know I am. Yep, I get it. Money is tight for people right now, so it is what it is. we're all good. So Firebase, Google's cloud platform, is actually a robust and secure service when configured properly. Storage buckets, in particular, require developers to configure access restrictions. Firebase, Google's cloud platform, Firebase is actually a robust and secure service when configured properly. Firebase, Google's cloud platform, is actually a robust and secure. So this paragraph is the same paragraph listed twice. Yeah. T never cared. It left its Firebase bucket configured for completely public access. No authentication required. No access logs to track who's downloading data. No encryption to protect the files. Just a URL that anyone could access. I actually, if I recall, like Firebase will yell at you if you don't like configure a password, right? Like if you don't actually set a password, it'll be like, are you sure? And be aware, you've got this publicly facing thing. Stop doing that. So the Firebase console literally has a section called security rules with templates for common scenarios. Setting proper access controls takes minutes. T either never bothered to look or looked and decided user security wasn't worth those minutes. T had no idea their data was being massively exfiltrated until reporters told them. No alerts for unusual access patterns, warnings about large download volumes, logging of who was accessing what. Even if T had some legitimate reason to keep verification data, which they've never adequately explained, I suspect that the legitimate reason is marketing. Why keep it all in one place? Why not encrypt it? Why not segregate it from production systems? Why not implement access controls so only specific employees could view it for specific reasons? The answer appears to be that T simply uploaded everything to Firebase and forgot about it. Fourth, the vibe coding problem. Multiple security experts who reviewed the breach concluded that T likely used AI-generated code for their Firebase implementation. The telltale signs were all there. Functional code that worked, but lacked basic security considerations. Default configurations left unchanged. No evidence of security review or testing. It's what happens when startups prioritize speed over safety when they trust ChatGPT more than security professionals. What is vibe coding? Vibe coding is people who just, instead of like programming, they get AI to spit out snippets of code. And so vibe coders are people who just sit there and spit things to the AI. Now, I kind of think that T probably isn't vibe coded because I don't think the timeline works, right? I don't think the timeline makes sense because T is like several years old. And so AI coding is fairly recent. I don't think that's what we're looking at here. I mean, I get what they're saying. I just don't see it as likely. So, yeah, I just, yeah, I don't entirely see it. So, I don't think that's a thing there. All right. Carrying on here. The perhaps what most damning is what T did have resources for. While they couldn't spare the time to secure user data, they had plenty of resources for marketing. While they couldn't afford proper security monitoring, they could afford Super Bowl ad campaigns. While they couldn't hire security professionals, they could hire growth hackers. The breach wasn't caused by lack of resources, it was caused by lack of caring. So, common injuries and damages. They say the T breach stands apart for the particularly cruel nature of its harm. This wasn't just data, it was trust. This wasn't just privacy, it was safety. This wasn't just another breach, it was a betrayal that put vulnerable women directly in harm's way. I mean, it's a little overwrought, but it's a complaint. We'll allow it. Yep. The psychological harm is equally devastating. Women who trusted T with their most sensitive information now live in constant fear. Every unknown phone call could be a stalker who found their number. Every piece of mail could be evidence of identity theft. Every knock on the door could be retaliation for a warning they posted. The safety app has made them perpetually unsafe. I don't think we're going to see a major uptick in violence. I'm just going to say. I don't think we're going to see a huge uptick in violence. There might be one or two incidents that happens, but I don't think we're going to see a big, we're not going to see dozens. We might see ones of that. So, yeah. Making matters worse, the data can never be fully contained. While a breached credit card can be canceled, the images T exposed will circulate forever. They're on 4chan archives. They're in torrent files. They're on hard drives around the world. They're in the hands of people who wish these women harm. I mean, fair enough. So the data breach increases victims' risk of identity theft. They're at a heightened risk of identity theft for years to come. Standard operating procedure for cyber criminals is to use some data to access full packages of a person to gain access to the full suite of additional personal identifying information that those cyber criminals have access through other means. Using this technique, identity thieves piece together full pictures of victims' information to perpetrate even more types of attacks. With full packages, cyber criminals can cross-reference two sources of personally identifiable information to marry unregulated data available elsewhere to criminally stolen data with an astonishingly complete scope and degree of accuracy to assemble complete dossiers on individuals. The development of fulls packages means here that the stolen personally identifiable information from the data breach can easily be used to link and identify it to plaintiff and class members' phone numbers, email addresses, and other unregulated sources and identifiers. In other words, even if certain information such as emails, phone numbers, or credit card numbers may not be included in the information that was exfiltrated, they can still create a fulls package and sell it at a higher price to unscrupulous operators or criminals, such as illegal and scam telemarketers, over and over. And they note, fulls is fraudster speak for data that includes the information of the victim, including but not limited to the name, address, credit card information, social security number, date of birth, and more. As a rule of thumb, the more information you have on a victim, the more money that can be made off those credentials. Fulls are usually pricier than standard credit card credentials, commanding up to $100 per record or more on the dark web. Fulls can be cashed out, turning credentials into money in various ways, including performing bank transactions over the phone with the required authentication details in hand. Even dead fulls, which are fulls credentials associated with credit cards that are no longer valid, can still be used for numerous purposes, including tax refund scams, ordering credit cards on behalf of the victim, or opening a mule account, an account that will accept a fraudulent money transfer from a compromised account without the victim's knowledge. So, loss of time to mitigate risk of identity theft and fraud. So, basically, this is going to be that they didn't, because everybody is affected, they have to spend time digging through shit. So because of the recognized risk of identity theft, when a data breach occurs, the reasonable person is expected to take steps and spend time to address the dangerous situation, learn about the breach, and otherwise mitigate the risk of becoming a victim of identity theft or fraud. What do I think of the AE campaign? I'm not sure what the AE campaign is. So failure to spend time taking steps to review accounts or credit reports could expose the individual to greater financial harm, and a defendant arguing that the individual failed to mitigate damages. So the need to spend time mitigating the risk of harm is especially important in cases like this, where plaintiffs and class members' government identification are affected. And Zeselek saying, going to take my first class for administration of justice this semester. Thanks to you. Thank you. Thank you. That is fantastic. Those alleged victims are claiming files worth more than medical hack files. It's a public good if libel by narcissists using tea are reported to victims of nutcase tea users. I mean, there may be some people who discover things are being said about them that are defamatory, and there may be some lawsuits around that too, right? There may actually be people who were targeted. Somebody goes online and says, oh, like this person did X, Y, and Z, right? So, yeah. Oh, the American Eagle campaign gene ads. I mean, that's not really a legal issue, but I think that a lot of the criticism is fairly silly. I mean, it is clear that the whole great genes thing is a dog whistle, but it's not really a dog whistle on, on racism. It's a dog whistle about saying she's got, it's a dog whistle for saying she's really attractive, right? That's what it's about, right? Is to say that she's like, that's what it's about. She's saying she's got great breasts. That's the whole point of it, right? So, yeah. That's my take on that ad, right? It's, yes, it has an ulterior meaning. It's just not the one people are assigning to it. Yeah. Crazy Cat Queen says, I finished up a second bachelor's degree, BS criminology. Magna C. Loud, thank you so much. I suspect YouTube would have had a note there. Last weekend, I think I'm going to celebrate with a new tattoo. 3 weeks and I start grad school. If you could celebrate with me by trying some hot sauce, please. I could totally do that. 100%. All right. Where's the hot sauce here? I don't know if I've tried this one, or if I have, it's been a while. It's the Good Hurt Fuego hot garlic pepper. So, all right, let's try that. All right, the spoon is got other hot sauce on it, so I don't have a good hot sauce spoon. What do I have here? I'm just going to use the cap. All right. So it's vinegar forward. It's not too spicy, but it's not. I'd put it at like a 3 out of 5 on the spice meter. It's pretty simple: vinegar, aged red cayenne, and habanero peppers, salt, garlic, xanthan gum, guar gum, natural flavor. I mean, you can taste the garlic. You can taste, and it's got. I'd say it's a good replacement for like a Frank's. I like that a lot better than a Frank's, and it's kind of a similar style. So, yeah. I hate vinegary hot sauces. Then you won't like this one. It is a vinegar base, and it's clearly a vinegar base. So, yeah. All right. So basically, they're going to have to spend a whole bunch of time on this. And you might be saying, why are they talking about time in a lawsuit? Well, the reason why they're talking about time in a lawsuit is that they're going to say, well, you could have spent that time doing other things like making money, that time is worth money. So yeah. Using a hot girl to sell jeans is not a new idea. That is pretty much it. It's, look at her, isn't she attractive? And then jeans pun, right? That's really what it's about. The future cost of credit and identity theft monitoring is reasonable and necessary. By the way, I would bet a lot if they, or I would bet a fair bit that American Eagle will do a follow-up ad using, somebody else other than Sydney Sweeney, using the same jeans pun. All right. Retail cost of credit card and identity theft monitoring could cost $200 or more per year per class member. This is a reasonable and necessary cost to monitor and protect class members from the risk of identity theft that arose from the data breach. This is a future cost for a minimum of 7 years that they would need to bear but for defendant's failure. Now, keep in mind, with a class action lawsuit, about half the money in a class action lawsuit tends to go to the lawyers. And then like the remainder tends to get divided up among the class members. So what I expect you'll see is like the lawyers buy themselves a yacht, and then you're going to see like the class members get something like 3 years of credit identity theft monitoring, right? So class action lawsuits are important. They're necessary. They are really critical to our system for being able to address, these kinds of diffuse harms. But at the end of the day, the lawyers get rich and the class members get very little. So, if you're just if you've ever like signed up for a, if you've ever signed up for like, or being a member of a class, it's like, oh, look, I got a $20 gift card, right? So class action lawsuits really exist in order to hammer a company that did wrong, right? So it's, lawyer gets the yacht, victim gets the pool noodle. You're not wrong. All right. So, excluded from the class of the following individuals or entities: defendant, defendant's parents, subsidiaries. When they say parents, they don't mean like their dad. They mean they mean like parent companies, subsidiaries, affiliates, officers, and directors, and any entity in which defendant has a controlling interest. All individuals who make a timely election to be excluded from this proceeding using the correct protocol for opting out, and all judges assigned to hear any aspect of this litigation, as well as his immediate family members. So now they're going to get into why is this a class? Well, numerosity. The class members are so numerous that joinder of all members is impracticable. Class actions are for situations where you've got like 500,000 people or 100,000 people. But if it's 4 people, right? If you've got 4 people, then they would just say sue individually, right? Question: why would you want to opt out of a class action suit? When you are in a class action suit, you are getting money as a representative of the class. And the money you get as a representative of the class is typically a fairly small portion, right? But let's say the class action is with respect to, I don't know, well, we could use this tea lawsuit, right? Let's say that you are a woman who is using the tea, right? You might be like, okay, I'm good to be, a member of the class, and you're going to get like $12 or something at the end of it, right? You get your $12 and you're like, yay. but you might be a specifically and much more harmed person. Like you might instead be like let's say your ex showed up at your door because you used to be involved with some scary ass dude, and that ex specifically discovered your new address based on your use of the T app, and then shows up at your house and like cuts off your leg with a chainsaw, and you survive, but now you got no leg, right? That leg missing thing, you're going to say, well, that's worth way more than like $12. I don't want the $12 for being a class member. I want the money for this guy chopped off my leg. So you might sue for, like, I have a specific, unique additional amount, and so you want to opt out so that you're not part of the class so that you can sue on your own, right? Commonality. There are questions of law and fact common to the class which predominate over any questions. Commonality is basically if you've got like, 100,000 people as the so if you've got like 100,000 people in the class, they better all have the same issues, right? So let's say I get 100,000 people as the class to sue McDonald's. But like one person suing McDonald's because they burned themselves with, with like a hot chicken nugget. Another person is suing because like the food is gross. Another person is suing because they don't like the arches and they think it's like anti-Semitic or something. And everybody in the 100,000 group is suing for different things. Well, then they don't have commonality, and so that's not going to go, right? So they're just listing all of the things. Typicality. Plaintiff's claims are typical of those of other class members because their personally identifiable information, like others, was compromised in the data breach. So basically for typicality, you want your class representatives to be people who are sort of good examples of everything, right? So let's say a cruise ship runs aground and everybody has to be evacuated and they lost their cruise and they lost property and so forth, right? A typical member will be a person who had a cruise planned, lost the cruise, has a bunch of luggage, etc. But there might be atypical members, right? You might have somebody who is atypical because they quit the cruise 3 stops earlier. They were like, nah, bro, I'm done. And they left. They're atypical because their damages are basically going to be nothing. Or they might be atypical because they were extra seriously badly injured, right? They were the person who, when the ship ran aground, like they actually got like injured by spraying, metal shrapnel that like, or, their property was specifically worth so much more because, they were carrying diamonds. You don't want the outliers. You don't want the weird people. You want the people, and especially you want the people who are legally the same, right? So you want the people who have no extra additional legal arguments. So, for example, with that cruise ship thing, right? Let's say you have an additional legal argument because the cruise captain, like, on your way out, the cruise captain stabbed you. Personally, like, stabbed you. Well, you are not typical anymore. Like, you're not a good representative of the class because most of the people on the ship were not stabbed by the captain, right? The captain went "Arr" and busted out his cutlass and stabbed you specifically, and now you specifically have this claim of being stabbed, right? So that creates an atypicality. Adequacy of representation is basically the plaintiff isn't going to give up, and they hired a good lawyer. Predominance, so they're basically saying we should get to take the lead. Superiority, a class action is superior to other available methods for the fair and efficient adjudication, and no unusual difficulties are likely to be encountered in the management of this class action. This is basically the court saying the class action is the best way to go, right? All right, claim for relief. Negligence, because they did the things. We already have really covered all of that, but so negligence. Breach of implied contract. You guys promised that you would keep our stuff safe, and then you didn't. Invasion of privacy, public disclosure of private facts. Well, that one's fairly self-evident, right? That one's pretty obvious. Count 4, violation of the California Consumer Records Act, which basically says, hey, all of our information's got to be kept secret, and if you maintain it, you've got to, preserve it. And they were required to notify the owner or licensee of the information, the data breach immediately, which they didn't. So, prayer for relief. What do they want? Well, they want money, but they, so for an order certifying this as a class action, for equitable relief, enjoining them from engaging in the wrongful conduct, injunctive relief, preventing them from engaging in the wrongful acts, requiring them to protect, including through use of encryption, all data collected through the course of its business. I'm just going to note, T is probably going to go out of business. T is probably going to get sued into oblivion. And then all of this information is going to get sold by a third party or to a third party. So prohibiting defendant from maintaining the personally identifiable information on a cloud-based database. Oof, that would increase their cost tremendously. Requiring defendant to engage independent third-party security auditors. So just basically requiring them to do business sensibly. The big thing, the real thing, is for an award of actual damages, compensatory damages, and nominal damages in an amount to be determined, and for punitive damages as allowed by law, and for an award of attorney's fees and costs, pre- and post-judgment interest, that's additional money, and such other and further relief as this court may deem just and proper. So, that is one of 6 lawsuits, and we'll probably have a T segment going forward on Mondays. We'll probably do a T segment like just every Monday. Just every Monday we'll do a T segment because we're not going to run out of tea anytime soon. There's so much tea out there. It's just going to be nuts. Now, some of them do have some overlap because they have some, they have the same lawyers. And, yeah. So, wait, there are 6 of them? Yes, they are screwed. Yep. All right, let's cover some super chats, and then we will cover something fun. Jen Edwards and Lana the Kitty, thank you for the YouTube membership. Welcome aboard. Pop Princess, Ian, I hope you feel better. Still recovering because like a flu takes a lot out of you, and my throat is killing me, believe it or not. Ash Axiom, hello, celebrating my 23rd month membership. Thanks, thank you. David Starbuck says, took my Glock 34 out to the range today. My P320 stayed in the safe. That is a good place for it. That is an excellent place for it. Also, I don't know how we got to 11 out of 10 on our goal, but we did, so that is a good thing. Yeah. All right. I'm going to start another goal. We're going to go through the fun case anyway, but I'm starting a goal for it. Brentwood Chic, good evening, Runkle, mods and chat. Good evening. Ash Axiom Goals, thank you. Tony P, are you sure you wouldn't rather pour some gin? Thanks for going live tonight. I might, but I don't want to actually go through the effort of mixing something tonight. So yeah. Katie Huling, for this goal and the pro bono goal, just dropping in on my dinner break. It'll probably be done when I'm off work, so I'll be replay crew. It'll be good to see you. Brendan Sheik, quick, let's hit the goal. A beer is needed for this craziness. You're not wrong. Sandy, feel free to crack one open for me. Will do. Brentwood Sheik, thank you for 10 gifted memberships. Jen DeSimio, thank you for the membership. Thank you for being here. Stephanie, cheers, Ian. Cheers. Joy W, I have nothing profound to say. Just hi and crack a beer. Thank you so much. Brentwood Sheik, more green needed in the chat. Gifts incoming. And then we have... Thank you for 20 gifted memberships. Much appreciated. KPT, in honor of our daughter's 28th birthday today. Thank you so much. Just because, and happy birthday. Bob, short for boy on bike. I always think born on board, but that's a game reference. Wait, is Bobby, or Bobbert the witness? Let's go with Bobbert. Brentwood Cheek. So tea spilled their own tea? They did. Jamie F., happy Monday. Glad you're feeling a little better. Still not 100%. I wanted to get some like spicy soup on the way back, and the spicy soup place is closed because it's a long weekend. So yeah, it wasn't there. Unlike some failures pretending to be copyright lawyers, whom we definitely can't think of by name, Runkle has all the tea, the deets, and the receipts. Thank you so much. Throat killing you? Take a COVID test if you've got razor blade throat. Thank you. I don't think... Well, first of all, I did take a COVID test. It's not COVID. Second of all, my throat is killing me because I've been talking a lot. And, yeah. Was it Korean sundubu? No, I don't really know of a good sundubu place in Edmonton. It's what do you call it? Vietnamese bun bo hue. I'm probably mispronouncing it, but yeah, it's good. But yeah. Thank you for the YouTube membership. Much appreciated. Volka, see the rest of this tomorrow. Have a good night, Ian. Hope Starlink does what you need. The Starlink was actually working great, believe it or not. Leah Baker, we love you. Thank you so much. Against the Tide, please like to help Ian reach his pro bono goals. Thank you so much. Cat's Pajamas towards the go bag goal. We'll talk about that too. Deaver's missing integrity and La Posada's Disco Inferno. Running theme lately seems to be everyone's overly confident in their own work and don't want to hire people to double check it, engineers, editors, etc. You're not wrong. Kasha 4986, can a person on this app ask the person who rates the dude why they've left that rating or why they made that comment, or are they just there? There seems to be DMing options. Super Iron Bob, timeline of T bring up is too early for the vibe code theory. It's the same error class that vibe coding is prone to, but not a good area theory. Yeah, I agree. Jamie F. Goal, in the U.S., we always lock down all 3 credit reports so no one can open accounts in your name. It's good practice. Canonical Heat, please do the YouTube things. Like, subscribe, those things. You know what to do. Thank you so much, Canonical Heat. And here. Canonical Heat, thank you so much for 20 gifted memberships. Much appreciated. Oleg Mamatov, sir, same question keeps coming up at my range. Can one travel with snap caps in the 12-gauge gun, obviously properly stored and locked in the car? Yes. Snap caps are not ammunition. A gun with snap caps in it is not loaded. So, Patty P, thank you so much for being a member. Much appreciated. Mildred Katie, would have been earlier. Hubby equals priority interrupt. You're not wrong. Wani MH, favorite gin, in my opinion. No mixer needed if you sip in a small snifter out of the freezer. Uncle Val's. Never had Uncle Val's. I don't think it's made it north of the border yet. GA Hello Kitty, thank you so much. Martha Ivy, thank you for your expertise. Thank you for being here. John Smith, I saw someone load a 300 blackout in 223. Ooh, For the people who don't know, that is a great way to destroy a gun. 300 blackout loaded into a 223 is a great way to, is a great way to make your gun go boom. So, is your wife still going to Mars one day? Probably not. That company fell apart. So, yeah. All right. So, people were asking about the get home bag. So, what is a get home bag? The basic idea is if you are out and about, like if you're at work or wherever it is you spend time, and things go badly, let's say there's a riot, let's say there is let's say there is, civil unrest, a reign of toads, whatever, right? The question is, the question there is basically, how do you get home? Like, what do you, and so you may have heard of, this is a great, a bug out bag, but in reverse. So a bug out bag is the idea of having a bag of stuff to grab and leave your house in a hurry. Well, this is not that. This is a bag designed to, like, to get home. So now what needs to go into a get home bag will depend on, it'll depend a bit on what you, like where you are and what you're doing. Because, for example, if you, what's a good example here? Let's say you are, let's say you're working in a rural area, right? Well, you're going to have different needs for your get home bag than if you're working in a urban area, right? So, so one of the first things to consider for a get home bag is where do you need to be, and like how long is it going to take? So, the one of the main considerations I have for a bag, the bag itself, is the bag itself should look boring. I do not want for my get home bag something that looks super tactical or anything like that, because in the event of like chaos, people will be looking for somebody who looks scary and somebody who looks, somebody who looks out of place. And so, as much as I would love to say, like, here is an Amazon link to a really cool looking bag, and I'm not going to do that. Really, the thing to do is get like a backpack that you picked up at like a Value Village or something, some secondhand backpack that just looks like a student bag, right? That's really all you're looking for, is like a student bag, not some super tactical whatever. The next thing is, like, I put on Google Maps, I looked at, I looked over at the, how long it takes to walk home from like my usual, like just from the courthouse. And it says it takes like, 8 hours to walk home. So, and I'm fudging that just to sort of whatever. So, well, let's triple that. Let's say not just 8 hours, not just 16 hours. Let's say, okay, that takes us up to, what is that? 24 hours. All right. So we're going to say we're going to be taking 24 hours, right? All right. So now we're looking at this. What else are we going to look at? Well, I throw a map in mine, and the map in mine is like, it's a paper map, and I've got stuff marked on my paper map that, that, like, directions that I might go. I might, alternate routes. If my route is blocked, how else can I get there? Because I'm a lawyer and sometimes I have to walk in, sometimes I got to be in court in like stupid, idiotic shoes. I put like a set of running shoes in there, right? So I put running shoes, that I can change into. I like big, heavy socks, especially if it's winter. Big, heavy socks go in there. Like a spare set of glasses. These kinds of things. What I don't have is I don't have this. I don't have a life straw in my bag. I actually do have water. And the reason why I don't have a life straw in my bag is that I'm spending most of my time in the city. And in the city, most of the water that I'd find is still no good even after you run it through a life straw. Because you run it through a life straw and all of the like gasoline that's contaminating it still comes through the straw. So, a Silcock key might be useful, but that's kind of a, thing to think about. Now, if I was for a rural thing, like for a car get home bag, I would put a life straw in because it makes sense, right? You could drink out of a puddle with it so long as that puddle isn't contaminated with, with oil. Now, I'm not going to sort of detail everything. What's a life straw? It's a filter for, it's like a water filter, just a personal water filter. I'm not going to detail everything. I will make a video at some point where I talk about it, but the fundamental considerations are what does it take to get home? In areas where it's allowed, I'd keep a weapon. I'm not in an area where it's allowed, so no weapons. But, all of these things are worthwhile to think about. The other thing to think about as well is if you work at a constant place, also consider just a stay-in bag as well. And what I mean by a stay-in bag is that it might make more sense before you start walking home to instead think, is it a better idea to just stay where I am? Because let's say you are on, let's say you're on the 30th floor of an office building. Okay, that's not a great place to be, but it might also be not a bad place to be, especially if, if the bottom floor, if the reason why you want to get home is that, like, there are riots and some of the rioters have guns and shit like that, you may not want to be like, well, I'm going to go walk home through that shit. You might instead prefer to be like, well, I'm up on the 30th floor. The rioters aren't. Maybe I just want to stay here, right? Maybe I want to, not go anywhere. So all of these are worthwhile considerations. But the main thing, lots of people put way too much shit in it. Like you'll see online people talk about their go bag. And their go bag will include things like, a full-size axe or like, sword. I mean, sure, I can think of situations where sword might be useful. This thing also weighs a ton. I don't want to carry this home. And I certainly don't want to be like encountering panicky police while I'm holding it. So, like, sword is not going into my get home bag. I have seen things, I've seen people include all sorts of crazy stuff in them. And I'm just like, no, that's crazy. And when you've built a get home bag, the other thing you should do, the other thing you should really do with it is test it out. And the testing out sucks. Why does it suck? Because if it takes 8 hours to walk home, well, Your testing out is you're walking home for 8 hours with your bag. And ideally, the way to test it out is not to plan the test. It should be, but it's not really feasible for most people to have like a random choice. So you pick a Friday when you know you don't have anywhere you got to be, and you just like take the stuff that you have on you, and it should only be like the normal stuff plus your get home bag, and then you walk. And it's probably a long walk, and just test it out, because you will find out things you miss, right? And the other thing is, plan for your walk to suck, and plan for your first walk to fail. Like, plan that you might get a quarter of the way and then get on your phone and get an Uber for the rest of the way, right? Because you might discover that that there's things that don't work. You might discover that your shoes need to be better than you thought. You might discover that you didn't have nearly enough water for a sunny day. You might discover that you didn't have nearly enough coat for a cold day, right? All of these things, right? And it's worth having. And I see people noting, I work at home. I also have like just a car bag. And the car bag is for like, if I, if my car goes off the road, am I going to be okay? Am I going to be all right? Yeah. What is the predicted number of times you will need the bag over a lifetime? 0. The ideal number of times to need the bag is 0. But I can tell you the car bag that I have for staying off, like for if I get stuck off the road, the expected number of times to need it is 0. The number of times I've needed it is 1. And the number of times I've thought I might need it is another 1. And it wasn't there when I had it. So when I was thinking that, and I was like, ooh, I don't like this. So I keep stuff in my car, right? Because if you end up off the road, if you end up stranded somewhere, what are you gonna do? So, yeah. All right. Let us cover one fun case. And we're not going to cover all of it because it is 51 pages. And 51 pages is not fun. We're going to cover some of it because 51 pages is too much. We'll have to sort of go through some of it, not all of it. But all right, here we go. This is the case of Frankie Johnson versus Jefferson Dunn. And what do we have? Oh, we got a swoop. Swoop is here. Sanctions order. This case is before the court because incarcerated plaintiff Frankie Johnson accused defendant Jefferson Dunn, the former commissioner of the Alabama Department of Corrections, of fabricating citations to legal authorities in 2 motions. The prisoner accuses the commissioner of the Alabama Department of Corrections of fabricating citations. The prisoner is the one accusing the other side. 3 attorneys for defendant Dunn confirmed in writing and at a hearing that the citations were hallucinations of a popular generative artificial intelligence AI application, ChatGPT. In simpler terms, the citations were completely made up. The court must determine an appropriate sanction. Fabricating legal authority is serious misconduct that demands a serious sanction. In the court's view, it demands substantially greater accountability than the reprimands and modest fines that have become common as courts confront this form of AI misuse. As a practical matter, time is telling us quickly and loudly that those sanctions are insufficient deterrents. In principle, they do not account for the danger that fake citations pose for the fair administration of justice and the integrity of the judicial system. In any event, they have little effect when the lawyer's client, here an Alabama government agency, learns of the attorney's misconduct and continues to retain him. And yeah, this is the thing. I used to be a prison guard. We actually got sued by inmates constantly. Absolutely, prison guards get sued by inmates constantly. And most of those lawsuits are bullshit. And that isn't because that isn't because prisons are like sunshine and lollipops. It's just that prisoners tend to file lawsuits that really suck. So, an appropriate and reasonable sanction must, one, have sufficient deterrent force to make this misuse of AI unprofitable for lawyers and litigants. Two, correspond to the extreme dereliction of professional responsibility that sham citations reflect, whether generated by artificial or human intelligence. And three, effectively communicate that made-up authorities have no place in a court of law. For the reasons below, the court publicly reprimands Mr. Reeves, Mr. Crawford, and Mr. Lunsford for making false statements to the court, orders publication of this order to effectuate that reprimand, and this is the big one, folks. This is the hammer. Disqualifies them from further participation in this case, and refers this matter to the Alabama State Bar and other applicable licensing authority. They punted the lawyers off the case. The government lawyers got punted off this case. Yeah, that is exceptional. And then they released without sanction attorneys Daniel J. Chisholm and Lynette E. Potter and the law firm Butler Snow from disciplinary proceedings. So, yeah. Procedural background. Defendant Dunn filed a motion for leave to take the deposition of an incarcerated person under federal rules of civil procedure, which is required to depose any incarcerated person. Signature block of that motion contained the names of 4 attorneys from the Butler Snow law firm: William J. Cranford, William R. Lunsford, Matthew B. Reeves, and Daniel J. Chisholm. Mr. Cranford electronically filed the motion with his filing credentials. Plaintiff Johnson, the incarcerated person at issue, objected to being deposed prior to receipt of certain documents from the Alabama Department of Corrections that were the subject of a motion to compel by him. All parties agreed that Plaintiff Johnson was due to be deposed. The dispute was simply about when. So basically, he's like, I don't want to be deposed until I've got the documents. On May 8th, Defendant Dunn sought leave of the court to file a motion to compel interrogatory answers and document production from Johnson. Next day, the court granted that leave. They filed an unopposed motion for excess pages. And, yeah, skipping ahead a little bit. Next day, Plaintiff Johnson filed a response to the motion for leave to depose him. They objected to a deposition the week of June 3rd on several grounds, including that counsel for Defendant Dunn appeared to have fabricated citations to legal authority in his motion for leave and motion to compel, possibly through the use of generative artificial intelligence. In total, there were 5 problematic citations across 2 motions. They cite United States versus Baker. And this case is an actual case. It's an appeal challenging a criminal sentencing enhancement, and it doesn't discuss discovery. So it's a real case, but it's not correctly cited. Defendant Dunn cited Kelly versus City of Birmingham for the proposition that the district court refused to delay deposition based on unrelated discovery issues. And the only case that style that they could find was an Alabama Court of Appeals case from 1939 that dealt with a traffic offense. Greer versus Warden, rejecting an inmate's request to delay deposition until additional discovery was completed. This case does not exist, nor does a case exist with a similar citation for that proposition of law. Wilson versus Jackson. There is no such case, and the Westlaw number directs to a maritime personal injury case that does not discuss discovery. Williams versus Asplund Tree Expert Company. Though a case with that style exists, no case with that combination of style and proposition exists. So, as per usual, the court issues a show cause order noting that in light of the seriousness of the accusation, the court had conducted independent searches for each individually fabricated citation to no avail, and ordering the signatories of defendant Dunn's motion for leave and the Butler Snow law firm to show good cause why they should not be sanctioned. 3 hours afterwards, Mr. Lunsford and Mr. Chisholm filed a motion to be excused from the show cause hearing. Mr. Chisholm and Mr. Lunsford represented that neither of them participated in any way in the drafting or filing of the motion for leave to depose incarcerated persons, and that Mr. Lunsford must be in Macon, Georgia to prepare for and attend a previously set evidentiary hearing. And the court was like, fuck you, no. Asplundie. Okay. Court was like, fuck you, no. You are going to be here. No, you do not get to weasel out. Be here now. Several attorneys representing other parties sought and received excuses from the show cause hearing. So, Ms. Lynette E. Potter was also added to the show cause, and they filed a response admitting that the citations were hallucinated by ChatGPT. In short, attorney Matt Reeves used ChatGPT to obtain case citations in support of two arguments made in the motions at issue without verifying their accuracy, and those citations proved to be false. Mr. Reeves specifically is thrown under the bus. Butler Snow then filed its response, called the events unacceptable, and requested that any sanctions be proportionate to the wrong and commensurate with each attorney's roles in these events, and that its client not be sanctioned, and for counsel to have the opportunity to file an amended motion with correct citations. So, William Cranford, he's of counsel at Butler Snow. He stated in his initial declaration that he drafted the initial version of Dunn's motion for leave to depose incarcerated persons, submitted the draft motion to leave for review to his direct supervisors, Matt Reeves and Bill Lunsford, while copying Mr. Chisholm. So, and that the revisions included the string citation at issue in paragraph 2 of the motion for leave. Although he reviewed the evidence for grammatical and typographical issues, he did not conduct an independent review of the legal authorities added and incorporated the revisions into a final draft for filing with the court. And that he possessed no knowledge that Matt Reeves used generative artificial intelligence. So basically, I didn't know. I'm a junior. I submitted this. The court, my superiors added this, and yeah. All right, so that's his sort of take on things. He apologized and accepted full responsibility. He says, I signed these motions. I understand that by signing these motions, I was verifying and accepting responsibility for the content, and I take full responsibility. I mean, good for him. That is better than usual. He also states that he's never used any publicly accessible artificial intelligence chatbot to generate legal or other authority citations for submission to any court. Reeves. Mr. Reeves is a partner and assistant practice group leader in Butler Snow's constitutional and civil rights litigation thing. And he notes that he performed a search on ChatGPT to identify supporting case law for the proposition that discovery may proceed even during the pendency of other discovery issues, such as the motion to leave, and that he failed to verify the case citations returned by ChatGPT through independent review in Westlaw and Pacer. And quite frankly, this to me is absolutely insane that people are doing this still. He says that he's had limited use with various AI products. And besides Westlaw's co-counsel product, he stated that he used ChatGPT initially for personal reasons to look up things related to dietary-related matters and to look up things when his family went on trips. And when his youngest son started looking at colleges, doing some research on that for colleges and universities. Stop using ChatGPT for lawyering at all, because ChatGPT does not lawyer ChatGPT or researching at all, because it doesn't research. It makes shit up, and it's pretty good at making shit up that sounds right. And because it sounds right, it might be, it might be correct, but it might not. So, like, if you ask, like, where's the safest part of, like, if you ask ChatGPT for a recipe, it may throw stuff in that sounds like it should be in a recipe, but it'll throw, like, okay, a tablespoon of salt into your, your sugar, your sweet dessert, because it doesn't know better. It's like lots of recipes have a tablespoon of salt, so... All right. So he gave examples of basic tasks such as a general search of any sort of background, history kind of stuff for a witness that was going to be deposed, or to get a survey of what was out there publicly available to get an idea of what the body of policies in the corrections world looked like. Neither of these are appropriate, things. Neither are appropriate. It's I don't get it. So yeah, this is bizarre. I mean, somebody online should probably, this would be a fun thing to just go on like ChatGPT and ask it for recipes and then like just produce them. So yeah, we'll we'll have to see. I mean, I suspect some of them would be okay and some of them would be awful. All right. He also stated that he was aware of a limitation on use of artificial intelligence products at Butler Snow, and that he didn't comply with the firm's policy. So the firm has a policy saying, do not AI. And so what does he do? Well, he AIs. Because he has the dumb. So, yeah. And that he's going to take a program on don't use AI. Cool. And he says that because he's the one responsible for the error, he hopes that the court will not punish his colleagues for that. William Lunsford, partner and practice group leader at the Constitutional and Civil Rights Litigation Group at Butler Snow. He apologizes. What's his issue? Well, yeah. Let's see. He says that he's represented the Department of Corrections. He stated that he did not review the draft due to other work obligations, that he did review the motion to compel, and that he basically says, I didn't check the citations. I checked the facts outlined as the basis of the motion. Did not conduct any detailed or substantive review of the legal authorities. He said, given that the document had already undergone a review by Matt Reeves, I did not conduct any level of detailed review. He's like, I thought the other guy had it. And He described Mr. Reeves adding legal citations as a supervising attorney to be atypical and rare. So, yeah. Basically, he's like, I added my name to it. Mr. Chisholm. Mr. Chisholm is an associate at Butler Snow. In his declaration, he stated that although he was copied on email circulating drafts, he did not draft, revise, or review the motions at issue. He reaffirmed that statement at the show cause hearing. In a supplemental declaration, he stated that he's never used any publicly accessible, like no AI. So Chisholm gets cut loose because he's a junior. He was copied on it, but he didn't do anything, right? He didn't do anything. What is it? A bunch of people used AI in our methods class. They barely passed only because the instructor was a PhD student and didn't want to ruin someone from graduating, but the email she sent, scathing. I will just say, I have taught law school before. I will teach it again. I hope. And I can tell you that what I'm likely to teach is firearms and weapons law for Canada. It's what I it's what I am sort of most interested in. I can't necessarily guarantee that I would catch you using AI, like that I would catch what exactly, I can't say necessarily that I'd be like, all right, I have discovered that this person is using AI. I can say that I would not necessarily be able to tell the difference between your use of AI and your simply being a moron. And the problem is that none of the AIs I know about know anything about Canadian weapons law. So, I'm just asking Grok a question. So I asked Grok about plastic brass knuckles. And it is correct on some things, but it also includes some vastly incorrect things. For instance, it says that carbon fiber knuckles are illegal, which is not actually true. Yeah, I mean, what is the leading case in Canada on evidence at a firearms hearing? Searching. And it's wrong. And it's so wrong. It is, it's giving me a case of Sabiston. And I can tell you that if you said Sabiston in, a test that I was running or on a paper, I would fail you because Sabiston is not the right case for this. Sabiston is not the right case at all. It is completely off point. Entirely. Sabiston is a search case. It's not a firearm evidentiary hearing case. All right. Let's it is a case, but it's not a case that's useful. All right. Lynette E. Potter. She's an attorney. She didn't draft, edit, review, supervise, or approve the motions and possessed no knowledge about the motions. So she gets cut loose. Butler Snow, the firm. The firm notes that, Mr. Lunsford and Mr. Chisholm's motion to be excused from the show cause hearing should not have been filed. And that they did not find similar issues in other filings in this case and from within 9 filings from 3 different cases. So they did a more expansive review there. So they examined every citation in those 40 dockets and did not find any additional apparent AI-generated hallucinations. And they did this at their own expense. And so they say this is a one-off. It's just a one-off. Don't... But they also say that they have an internal policy stating that there are significant risks that LLM output can appear perfectly researched and logical, while in fact it is wholly inaccurate. And it requires written permission from the appropriate practice group leader to use this new technology as a secondary research tool with full checks of the accuracy of any results through traditional legal research methods. So they're like, we have a policy on this. And they did not follow our policy. So, yeah. Butler Snow basically seems to be getting a pass here because they're like, we're good. It's all fine. We didn't do anything wrong. These guys did wrong. And yeah. Office of the Alabama Attorney General. They're like, yeah, we are very upset by this and we are not okay with this. There is no generative AI platform that is authorized for use by the Attorney General's office. All right. So false statements of law. The hallucinated citations were false statements of law. Rule 11 conduct. We'll skip ahead a little bit. I'm just trying to skip a little bit here. If particularly egregious, the pursuit of a claim without reasonable inquiry into the underlying facts can be the basis for a finding of bad faith. So, findings and conclusions as to each attorney in Butler Shaw. Let's skip and just look at... Potter. Potter is released. Chisholm is released because he didn't have anything to do with it. Butler Snow, they're releasing because Butler Snow had good policies and there was nothing they could do to stop this person from doing it, right? So what is it? It finds that Butler Snow acted reasonably in its efforts to protect this misconduct or prevent this misconduct and doubled down on its precautionary and responsive measures when its nightmare scenario unfolded. No evidentiary basis for finding that the firm acted in bad faith or with recklessness such that its conduct was tantamount. Reeves. Basically, as the court understands Mr. Reeves' position, he does not contest his responsibility in any way and would prefer to be held solely responsible. And the court credits Mr. Reeves' representation that he will use his own experience in this case to warn law students and other lawyers of the consequences they might face if they make a similar decision regarding the use of AI. So Reeves, they're like, no. Having been so extensively alerted of the risk that AI will make things up and having blown through all of his firm's internal controls designed to protect court filings from counterfeit citations, Mr. Reeves' repeated decisions to parrot citations generated by AI without verifying even one of them reflect complete and utter disregard for his professional duty of candor, recklessness in the extreme, and is tantamount to bad faith. Cranford's going to be on the hook because he signs it. You sign it, you take responsibility. You're on the hook, right? Lunsford. His name and his signature appear on it, and he did review, and he didn't actually check. So, yeah. Lunsford also acted badly when he was asking to be let out of the hearing. So, first, Mr. Lunsford's request to be excused from the show cause hearing reflected an intense lack of concern for the seriousness of the misconduct that both Plaintiff Johnson and the court had described. So, Yeah. Now, if you're wondering, like, what kind of consequences will this have, this will have serious consequences because getting kicked off the file will be huge. And yeah, the court is well aware that disqualification often works substantial hardship on the client, but the court does not find hardship here. At the show cause hearing, the representative of the Alabama Attorney General did not suggest any hardship for defendant Dunn. This makes sense. The Attorney General's office has a ready team of capable attorneys who could step in to represent Dunn, some of whom already represent other defendants in this case. And even if there is some minor hardship, it must yield to the seriousness of the misconduct. So this case will remain stayed for 30 days for defendant's new counsel to have time to prepare. Reeves, Cranford, and Mr. Lunsford are ordered to provide a copy of this order to their clients, opposing counsel, and presiding judge in every pending state or federal case in which they are counsel of record. They shall also provide a copy of this order to every attorney in their law firm. They must comply with this requirement within 10 days and must certify to the court within 24 hours of that compliance that the requirement has been met. So they have to tell everybody they know, basically, that they got caught. And some of those clients are going to fire them, right? If you're sending an email to your clients and you're like, hey, I just got hammered by the court for using, AI, some of those clients are going to be like, bye, Felicia, bye, right? And I mean, I've got lawyers right now, multiple lawyers right now. And I can tell you, if any of those lawyers sent to me, hey, I'm using ChatGPT, like I just got sanctioned for using ChatGPT with hallucinated, citations, I'd be like, bye, you done. Please, please also whatever else. The other thing is that every other lawyer that they are up against, the opposing counsel, and every presiding judge is now going to go through and they are going to check every citation and they're going to be like, let's see if we can find misconduct in our file, because if we can, yeah, they're absolutely going to be going hunting, right? To further effectuate the reprimands and deter similar misconduct, the clerk of the court is directed to submit this order for publication in the federal supplement. Publish this shit to everybody. Publish it. Disqualified from further participation in this case, so their billable hours are ended. Mr. Reeves, Mr. Cranford, and Mr. Lunsford are directed to provide the clerk of the court with a listing of jurisdictions in which they're licensed to practice law within 24 hours. And you know why the court is asking, why are we, why are we going to find out everywhere else they're allowed to practice law? It's so they can send this letter to everyone else, too. Directed to serve a copy of this order on the general counsel for the Alabama State Bar and the other applicable licensing authorities for further proceedings as appropriate. Anna M. Manasco. Badass. Absolutely badass, right? And yeah. So I thought that was fun. I thought that was entertaining. A judge is like, nah, you suck. We going to war. Somebody's asking, what other channels do we watch? I'm just trying to think of what I watch. I don't watch a whole lot now. I used to watch much more, but I don't now much anymore. So just trying to think. What was the last thing I watched? So Akasha 4986. Well, now I need to know what a snap cap is. A snap cap is basically fake ammo. It looks like real ammo. Well, actually, some of them do. Some of them are vivid colors, but they're the shape of real ammo. And the reason why you use them is you put them in the gun, and then you could pull the trigger on the gun, and the hammer hits the cap, but it doesn't go off because it's just a dummy. So it's like a dummy, but they don't necessarily look like real things. They're used for practice. They're used for training. They're, that's what they're for. Yeah. Raining frogs is bad, but unlimited frog legs, not all frogs are edible. So I assume that with the rain of frogs, it's inedible frogs. Edward Kirkpatrick, Miles King, defense noted a potential witness is dead before defense was told to the witness. The question is, what might they have said? Absolutely. And I suspect the defense is going to say that, right? This witness is dead, and he might have been totally exculpatory. Hello, I love the pictures of you in the kayak. Makes me happy, and I'm celebrating because I found a place and my offer was accepted. Such adulting. That is awesome. You'll have to tell me all about it. And yeah, turn a real gun into a cap gun. Often it doesn't have like a cap that goes bang. It just goes click, right? So that's really what a snap cap is for. And Marmar, thank you so much. It was really great being out there, although I left the kayak out in the rain and then it filled with rainwater, so now I have to dry it out. Crazy Cat Queen, when the earthquake tsunami hit Japan in 2011, my cousin had to walk home from work in Tokyo because even in Tokyo, the trains and power was out. I think she had to walk all night in work clothes. This is why a get home bag is a good thing, right? You never know what's going to happen, and yeah, it's useful. Cat W, would heart videos for a bug out and get home bags. Thank you. I will do them. I just got to get around to it. It's tough. Leah Baker, thoughts on the Byrna as a self-defense for people not comfortable with guns for self-defense. I did a video on the Byrna. The Byrna is kind of a shitty option. I don't like it. I have a Byrna. I got the Byrna for doing a video. I would suggest that the better thing to do is to get comfortable with a gun. And the way to get comfortable with a gun is, just go to a range and shoot, right? Such, yeah. What's a Byrna? A Byrna is a little gun-like thing that shoots fake projectiles. It shoots like little, well, not fake projectiles. They're real projectiles, but they're like either pepper balls or like clay balls or the like. So, yeah. All right. Runkle, you look under the weather. Are you feeling okay? I am running out of steam here. So we're gonna wrap up soon, but we're just covering super chats here. Tough Cookie, thank you for 10 gifted memberships. Much appreciated. Annabelle Feinstein, my car bag came in clutch the night of the house fire. Had some basics for all humans and cats. See? Excellent. Big Apple Hoosier, thank you so much for the YouTube membership. And Shay. Shay B coming in hard with thank you so much for 50 gifted memberships. Huge. Thank you so much. I also want to address this before we go. Bear spray or wasp spray. Do not use wasp spray. Do not use wasp spray. Wasp spray is utterly ineffective. Wasp spray is a very, very bad idea. In fact, the only purpose for the wasp spray advice is that if you see people saying wasp spray, it tells you to not trust anything that they have to say on self-defense. And the reason why is because there have been situations where people have used wasp spray in self-defense, and the people who were sprayed thought that, like, they didn't realize that they were sprayed, right? They didn't realize that they thought that they got sprayed with water. Wasp spray, yeah, it works great on wasps. It doesn't work at all on people. It does very little for people. It's just, if you spray somebody with enough wasp spray, in 10 or 15 years, they might get cancer. And 10 or 15 years is not a good, it's not a good defense timeline, right? It's so lots of people say use wasp spray. It is the worst worst advice. It is just not good. I also see people saying use oven cleaner. I can tell you, oven cleaner will be effective for self-defense, but it will also pretty much guaranteed get you a charge, because oven cleaner will dissolve the fuck out of your eyes. I have a video where I tested out oven cleaner, and the oven cleaner like dissolved the eyes, and like it was not great. So yeah. Wasp spray is intended to be safe to use against wasps in a mass market, meaning it's safe for people. Wasp spray is basically built to be safe enough that if you accidentally spray your kid with it or your dog, that they're going to be fine. So yeah. In a pinch, who cares? The thing is with like oven cleaner and stuff is that people will reach for it in a situation that doesn't call for eyeballs, like eyeball dissolving. So yeah. Why not just get some bear spray? I mean, if it's legal, carry spray for people, because spray for people tends to be stronger than bear spray, believe it or not. So yeah. Bean brains, Benji gossip. That'll have to wait. We'll talk about Benji when we can, but yeah. Oleg Mamatov, no gun in your bag in Canada. Pretend your work is fine with it. It's trigger locked. No one can see it, and you're within arm's reach from it. The problem is carrying it home. You'd probably be possession of weapon for purposes dangerous to the public peace. It's a risk. Corey Cast, catching up on the stream. To be honest, I think the tea leak is what comes around goes around. Not saying that everyone who used it was toxic, but there are definitely people being toxic on it. I don't know any of what was said on it, but I suspect we're going to see a whole lot of discussion on we're going to see defamation suits. We're going to see all of that stuff, right? So yeah. All right, have I checked PayPal? I have not checked PayPal. Let's check PayPal. Ooh, there's a message from my brother that I got to respond to. So let's see. PayPal. 14 messages from one of my cameras, or 14 pictures from one of my cameras. That's a problem. I just put new batteries in the camera, and so yeah. Nothing on the PayPal, so PayPal is all clear. I see people saying hello to Brother Runkle. Brother Runkle is mildly annoyed about my YouTube channel existing, and I say mildly annoyed because what do you call it? No, my brother doesn't send me messages via PayPal. He sends me messages via text. And what do you call it? James Randolph says, I sent a PayPal earlier. I didn't see any PayPals. I'm just going to try pulling up PayPal. So my brother occasionally, he's a doctor. He's really, he's very smart. He's like really, I would have no, no qualms about being treated by him and so forth. He's really, yeah. Oh, and I see James Randolph saying, because YouTube didn't want their cut, let's hear about the get home bag. So there was a PayPal. Thank you so much, James Randolph. But what do you call it? Somebody says, is he single? No, he's not. So, but the name is not common. Like the name is unusual. And so he's been asked about me, like about my YouTube channel. And he's like, No, that's my brother. So yeah, it's I suspect he's like just like, you know, so yeah. And Yellow Pill says, thank you for your donation. I'm sure if you saw my email reply, thank you. People check out the check out that. People saying, so not a twin. No, he's actually like, you know, he's actually like good looking. I'm not. So um does Dr. Runkle also have flowing elf locks? No, he actually looks good. He does not look like a he doesn't look like sort of an itinerant homeless person. That's more my style. I need to know your hot sauce flavors. My husband makes it home. I bought him a first aid pack you suggested. He's a hunter. You're my hook to get him into LawTube. I mean, I have a hot sauce, but I don't have any to send right now. What is it? Hot sauce flavors. I mean, I like a garlic heavy sauce. I like unusual flavors. Like there's this Dawson's hot sauce, big smoke chipotle hot sauce. I was kind of impressed because it's actually got like a real smoke taste to it, and it doesn't have artificial smoke in it. So they've got to actually smoke it, which yeah, I totally want to check them out sometime if I'm ever out in Ontario. Did the allium free thing ever work? Not yet. I'm still tinkering with it. I have some ideas, but I have to actually test them out. All right, I'm going to wrap up here because I am exhausted. Cafe Olay is saying, "Can I have the Runkle Discord?" Yes. Let me get the link. Drop the link. What part of Ontario? I'm in Ontario, Hamilton, Ontario. All right. I will catch you guys later. I got to get some videos worked on and I got to get some sleep. I am exhausted. We'll talk soon. There's going to be more tea as sort of an ongoing thing because, yeah. All right. Good night, all. Halle Berry is saying, no, don't leave. I got to. My throat is worn out. So good night, all.